for our fourth and final panel, a great way to bring everything home after a very exciting day of topics and experts and dialogue in and outside of this room. So this final panel is very near and dear to my heart. It's something that really inspired my passion for the career path I've chosen. So environmental justice wasn't really a thing when I was in law school. I think it was formally coined as a field, perhaps when I graduated law school. I know that's a long time ago. When I was early in my teaching career, one thing that really energized where I wanted to go with my teaching and scholarly writing and engagement was environmental justice. Taught courses, did some writing on that, and then that morphed into climate justice. And here we have a symposium kind of built around those two themes that I've really had with me my whole career. And I'm really excited that so many people who are doing great things in these areas are assembled here today with us. And it'll be hopefully an ongoing source of reference and inspiration for us as we continue to embrace these issues and pursue them at GW Law. So we have a panel that's going to give you a nice broad view of the landscape of environmental justice. We're going to hear from Ariel King first, and she's going to provide more of make sure we're all on the same page on some of the background and historical context and principles driving environmental justice. And then we're going to hear three case studies that take a deeper dive into different aspects of how environmental justice communities have faced and confronted environmental justice issues. So we'll hear from Carlton Waterhouse on the community north of Richmond, very close to home. And then we'll hear from Rebecca Bratsby's and taking a look at a New York based case study, and close things out with Brittany Shar, taking a look at a Southern Georgia case study. So it'll be a nice way of really seeing how these issues and challenges manifest themselves in a variety of contexts. So Ariel King will start us off, well known as an environmental justice educator and activist, a great way to kick things off for us.
Good afternoon, everyone. I recognize that this is the last panel of the day. So I will do my best to keep you entertained. But yes, I think it's really important for us to just make sure that we are grounded in that understanding of environmental justice. So in this presentation, I'm really quickly going to provide a very general overview of the definition of environmental justice, add some historical context, explain a little bit of how it relates to the public health space, because this session is titled Environmental Justice in Public Health. I'm going to spend a little bit of time talking about cumulative impacts and how that relates to the environmental justice space. And then upon request, I will be very briefly talking about some of the things that I did while in law school to help elevate and evolve the environmental justice education at my law school while I was a student. So the official definition of environmental justice is a little bit amorphous. There is a definition that is well known and well recognized by the EPA. My personal definition is a little combination of a bunch of multiple ones. I believe that the environmental justice movement is a movement and framework that embraces the principle that all people deserve equal access to environmental protection and enforcement, recognizing that this, both historically and currently, often is not the case, and communities that receive the least benefits are experiencing the greatest environmental burdens. In the United States, these communities are predominantly low income and/or Black, Indigenous, and communities of color, which means that essentially the environmental justice movement is a continual fight for equitable distribution of burdens and benefits, or a more equitable distribution than what we have currently seen in our landscape. Did I? Uh-oh. This one. What do I press to advance this? Okay, well, while we are working on that. Okay, that seems risky. Okay, all right.
Let me.
Okay.
No, it's working.
Okay, which button is it? Which one?
4.
All righty. Boom. Okay, so in terms of the history of the environmental justice movement, there are two main events that are considered the start of this movement. What happened? No. All right. Boom. All right. The first is the Memphis sanitation strike. So the movement for environmental justice stems from the 20th century civil rights movement. In response to environmental inequities, threats to public health, unequal protection, differential enforcement, and the disparate treatment received by low-income and communities of color. As a result, the EJ movement is grounded in civil rights and a desire to ensure that civil rights are integrated as equal parts of environmental decision-making, governance, and enforcement. So one important way to ensure that this occurs is through ensuring that active engagement and public participation at all parts of decision-making are being prioritized. And a major part of environmental justice to me and to many environmental justice advocates is the pursuit of self-determination for the communities that are being affected. So essentially creating an ability for those who are being impacted by decisions to have a say in the outcomes of those decisions, which to me is it requires education, accessible education to help people navigate through all of these systems and remedies. And the kind of revocation of that self-determination is kind of the direct result of environmental injustice. And so one example that I talk about a lot in kind of describing and showcasing what self-determination can look like in the environmental justice context is what happened during the Flint, Michigan water crisis. Because I mean, for many reasons, but one of the main ones is that the mayor of the city was no longer able to make decisions. The state of Michigan had a rule called the emergency manager rule. And so if a city gets to a certain financial standpoint that isn't stable, it's very volatile, then an emergency manager was appointed by the governor who had no connection to this place, no real priorities aside from getting the city back into the black, which created decisions that extremely adversely impacted those people who lived in this city. So yeah, that is an example of self-determination being revoked from residents. So I have these two examples on the board to really explain how the environmental justice movement expanded the definition of environmentalism to where we live, where we work, where we play, and explicitly included people, which expands the obligation of what we must do and what and who we must protect. So the Memphis sanitation strike occurred in 1968. And it occurred as a result of workers demanding equal pay and better working conditions, specifically following a tragic event where two sanitation workers, Ethel Cole and Robert Walker, were killed by a malfunctioning truck. Black workers were paid less, had no benefits, and could not unionize. So as a result, over 1,300 workers from the Memphis Department of Public Works went on strike for weeks to support the families of those who were killed. This is actually where Martin Luther King gave his last speech. His I've Been to the Mountaintop speech took place here in Memphis. And one of the parts that I think is really important in this speech is when he describes that we've got to give ourselves to the struggle until the end. Nothing would be more tragic than to stop at this point in Memphis. Martin Luther King believed that the struggle in Memphis exposed the need for economic equality and social justice that he hoped that his Poor People's Campaign would highlight nationally. So the next example that I have on the screen is a few years later in 1982. We are moving a little bit north to or east? Yeah, like eastish, to North Carolina. And so in 1979, PCBs were banned by the EPA. And despite this, less than 5 years later, the government of North Carolina approved the dumping of over 30,000 gallons of PCB-laced soil into a landfill in a predominantly Black and Indigenous county in rural North Carolina. This is Afton, Warren County, North Carolina. And at the time, the population was 75% Black, predominantly low income. And after over 6 weeks of protest, which led to over 500 arrests, this landfill was not remediated until 29 years after this occurred. But this also created the groundwork for multiple different studies that proved the existence of a correlation between race and siting of hazardous facilities throughout the United States. Before we were able to get to a national study, the U.S. General Accounting Office created a study called the Siting of Hazardous Waste Landfills and Their Correlation with Racial and Economic Status of Surrounding Communities. A very, very long title. And it's from 1983. And that study revealed that 3 out of 4 of the off-site commercial hazardous waste landfills in Region 4, which is comprised of the 8 main states of the Southeast region of the United States, happen to be located in predominantly Black communities, even though the Black population made up only 20% of the region's population. The Warren County sit-ins is also one of the first times that we hear the term environmental racism. Okay, so what is environmental racism, you might ask? There are lots of different definitions, but the one that has been most popularized is by Ben Chavis, who you see here. He is continually a very, very strong advocate for environmental justice, social justice initiatives, and he was very active in the protests in Warren County. So as you see, there are 4 main elements: the racial discrimination in environmental policymaking and the enforcement of regulations and laws, the deliberate targeting of people of color communities for toxic waste facilities, the official sanctioning of the life-threatening presence of pollutants, poisons and pollutants in our communities, and the history of excluding people of color from leadership in the environmental movement. So within the last few decades, due to the lack of remedies in environmental laws, attorneys have used civil rights laws to seek remedies to environmental challenges, particularly in environmental justice communities. And this is a result of numerous amounts of data and reports that were created to prove the existence of a correlation between race and the placement of these toxic facilities. Prior to there being this official big report, there was a case that was the first time that environmental justice was used or litigated using civil rights law. This case was Bean versus Southern Waste Management Corporation. And it's the first case to challenge environmental racism using civil rights law. And essentially the facts are that Black homeowners in Houston were fighting against the construction of a new landfill in their suburban middle-class neighborhood. The residents formed a neighborhood action group, and their attorney filed a class action lawsuit to block the facility from being built. Part of this case was the development of a study by Robert Bullard, who is considered the father of environmental justice, a very, very prolific environmental justice scholar. And his wife was the attorney on this case, actually. And so the study that Dr. Bullard found, that he created, found that from the 1920s to 1978, nearly 60 years, 80% of waste management facilities were located in predominantly Black neighborhoods, when at the time, the Black residents of Houston made up only 25% of the city's population. And so these studies, these reports really dictated and emphasized what lived experience had already shown many communities of color across the United States. So finally, we get to the Toxic Waste and Race Report of 1987, which was created by the United Church of Christ Commission on Racial Justice, which is the first national study to correlate waste facilities and demographic characteristics. So race was found to be the most potent variable in predicting where hazardous facilities were located. Scientists calculated that Latinx populations in America on average breathe about 63% more of the pollution that leads to heart and different illnesses than they actually make. And similarly, for African Americans in the US, the figure is 56%, according to a study published in a National Academy of Science proceeding. And Dr. Bullard also explains that his and other past research shows that African Americans are 79% more likely than whites to live where industrial pollution is highest, with people of color overrepresented near Superfund sites and oil refineries across the United States. One of the clearest and most blatant examples of this, and we heard about this region a little bit in the keynote yesterday, is what we are now able to refer to as Cancer Alley, which is a 85-mile corridor it's a long stretch of communities along the banks of the Mississippi River between New Orleans and Baton Rouge in Louisiana. The people are living on the front lines of about 200 fossil fuel and petrochemical operations, which is the largest concentration of these plants in the Western Hemisphere. As a result of redlining and geographic location and landscape due to the high temperatures and proximity to water and the limited political power of residents, this was able to occur. Some residents face severe health issues, including elevated burdens and risks of cancer, reproductive, maternal, and newborn health harms, and respiratory issues. And like in most environmentally overburdened communities, though, residents are not simply sitting idly and allowing themselves to be victims of their circumstance. They are taking action, exposing the destruction, and taking a lot of these companies to court. There are plenty of examples of incredible organizations and groups who are advocating in this area. There is maybe something important to note. There are a lot of things to note, but in 2022, local environmental justice groups filed a complaint with the EPA that alleged that the Louisiana Department of Environmental Quality had engaged in racial discrimination under the Civil Rights Act. And in response, the EPA opened a civil rights investigation into the state's permitting practices. The state's then Attorney General, who is now the governor, Jeff Landry, challenged the suit on the disparate impact standard of the Civil Rights Act, which states that policies which says that policies that cause disproportionate harm to people of color violate the Civil Rights Act, which prohibits recipients of federal funds from employing any type of discriminatory methods or practices. So the suit argues that the EPA can only enforce the Civil Rights Act in cases where state policies are explicitly racist, and that imposing this disparate impact standard merely ensures that emissions are affecting the right racial groups. And so this enables the EPA to argue that it is discriminatory for state agencies to keep greenlighting contaminating facilities in communities of color already overburdened by pollution, even if official policies do not denounce discrimination as their intent. 5 weeks after this suit was filed, the EPA dropped its investigation, which essentially left the residents to keep fighting on their own. And during the hearing, the district court judge for the Western District of Louisiana essentially asked, why doesn't the EPA just move the people who live in this area? And offered that it would likely be cheaper to move residents than actually shut down these facilities, which, I think we could do a whole panel discussion on just that, right? Like that is truly emblematic of what we are dealing with as environmental justice practitioners. We are dealing with a legal system that has not necessarily been built to understand or support the disparate impacts that are felt by communities of color, low-income communities who are experiencing these overdue and disproportionate burdens. And there are minimal remedies at this point. We're gonna get to some of them, but yeah, so that's kind of the start of the landscape and where we're at right now. Let's talk about cumulative impacts. So cumulative impacts are an extremely important element of environmental justice. And so there are lots and lots of different definitions of cumulative impacts. One that I like to use is a collection of individual stressors that occur simultaneously and multiply, increasing the capacity for exacerbated harms and risks. So this is different from disparate impacts, primarily because the disparate impacts explains and just is related to those who are disparately excluded from benefits, and inflicts disproportionate shares of harm based on race, color, and national origin, whereas cumulative impacts is really just an analysis and understanding of the ways that all of these different impacts are harming one particular community. And so in 2005, the California Environmental Justice Advisory Committee recommended a definition to Cal EPA. I think this one's really good, so I'll just read that to you. Cumulative impacts are exposures, public health, or environmental effects from the combined emissions and discharges in a geographic area, including environmental pollution from all sources, whether single or multimedia, routinely, accidentally, or otherwise released. Impacts will take into account sensitive populations and socioeconomic factors where applicable, and to the extent that data is available. I like this definition mostly because it includes intentional and unintentional occurrences that will lead to these disparate impacts for communities and allows for that to be included into the context of a cumulative impact analysis. So one of the challenges with doing cumulative impact analysis in general is that there's really no clear framework yet to determine what a true analysis can or will look like. And that's partially because of the level of individualization and specificity that must occur for each type of analysis in each location. But there are certain elements that can be applied in multiple circumstances. So based on the EPA's definition of environmental justice, which includes the fair treatment and meaningful involvement of all people in decision-making, there are kind of two main approaches for integrating environmental justice into government programs. And I think it can also be applied to other contexts. One is identifying, characterizing, and integrating disproportionate impacts. And two is enhancing meaningful community engagement. So you got to talk to the people to understand what the challenges are, right? That's such a central element of environmental justice. And one possible solution to all of this, or to a lot of this, is mapping tools. Mapping tools have become a critical element of supporting identifying cumulative impacts on communities. So EJ Screen is the EPA's version of a mapping tool that is providing an opportunity to overlay different data sets so that you can understand how communities are being impacted by multiple different factors. And I believe that climate change is a multiplier and it contributes to cumulative impacts. And we're seeing this more and more. And that's why so many environmental justice advocates are talking about the fact that Black and brown communities, communities of color, low-income communities are experiencing the climate crisis first and worst because of all of the other factors that exist in our communities. So I want to highlight New Jersey's environmental justice law. Before I start this, I will say that I am a New Yorker through and through. And I've been taught to not say nice things about New Jersey, right? And so if I'm saying nice things about New Jersey, that means they're doing something very right. Anyway, so the new environmental justice law in New Jersey requires the Department of Environmental Protection to evaluate the environmental and public health impacts of certain facilities on overburdened communities when they're reviewing certain permit applications through what is called an environmental justice impact statement. And that provides an opportunity to identify existing health risks and factors, the presence or absence of adverse cumulative stressors, potential environmental and public health stressors associated with the facilities, whether a facility can avoid causing disproportionate impact, and where applicable, how the new facility serves a compelling public interest in an overburdened community. And so it's a very robust framework, and the EJIS is in addition to whatever EIS is required for the construction of a new facility. New Jersey is the first state in the nation to require this mandatory permit denials if any environmental justice analysis determines that a new facility will have a disproportionately negative impact on an overburdened community. Overburdened in this context is defined by census tract and like all of the different factors there. So I think there's a lot more that can be said, but I will not say it yet because I definitely want to leave a lot of time and space for everyone else's presentations. So I just really briefly want to touch on some of the work that was done at my law school. I went to Vermont Law and Graduate School. At the time it was Vermont Law School, but I got my master's in environmental law and policy and my JD there. And by the time when I started at Vermont Law School, it was the top school for environmental law in the country. But there was almost no environmental justice presence or education or really anything except for a student-led conference in 2016 that, a bunch of student groups can bid to be able to have this conference. And it was selected to be on environmental justice. And it was incredibly well received, well attended. And it proved that there was a need for environmental justice education on campus. I am using that as an example because that's kind of what this is, right? I think that there are a lot of unique opportunities to grow the environmental education presence here on this campus. And so, kind of showing some of this to inspire the students in the room to get involved and to kind of help create the curriculum that you want to receive. So while I was at VLS, In my first year, we created the Environmental Justice Law Society. It became an SBA-approved organization. Within my first semester, maybe a month after we got approved, we applied for a grant, got $20,000 to start doing environmental justice education for ourselves and the community at large. And that led to a bunch of other things, including a few multi-institution environmental justice convenings in Connecticut and North Carolina. And in 2019, the school launched an environmental justice clinic, which was a tremendous opportunity to be able to advance not only the education, but to support the state of Vermont and the country in providing environmental justice advocacy. And yeah, a few other courses have been offered, and there is an environmental justice symposium this weekend at Vermont Law School that I am keynoting. I'm very excited. But yeah, so very full circle. But yes, I wanted to share that because there are so many opportunities for students to get involved and to, like I said, create the curriculum that you want to receive. I believe that as environmental advocates, as civil rights activists, we have a duty to make this work accessible. We have a duty to make this work justice focused, and we need to be sharing that information in ways that other people can understand. And so, yeah, I mean, that's why I loved your keynote yesterday, because you spoke so beautifully about the need to create accessible education in this work and create pathways that really meet people where they're at. And I think that that's really what environmental justice is all about. So that's that. Thank you so much.
Thanks so much, Ariel. That was the perfect start to this panel. Really gets us all on the same page and really with a strong grounding in environmental justice as a field and its history and trajectory. Couple of things I wanted to highlight that I think are relevant not just for today's this panel, but the whole scope of today's coverage. Terminology, you know, the importance of terminology in what we're trying to achieve and in strategic considerations about how different ways of referencing and communicating what's happening in a particular context is something that we need to think hard about. So in this context, we're talking about when I started learning about environmental justice, I heard the term environmental racism quite regularly. And what you've heard from Ariel, there's a good reason why it was called, and perhaps should still be called, environmental racism. It's hard not to think of it as openly racist when you look at what's happened in a variety of contexts over decades, and particularly the disproportionate burdening of Black communities. That's where it started, and if you want to see where it still is, I recommend a documentary that just came out, The Smell of Money. So this is happening in a whole new context now, in the disproportionate burdening of Black communities living on the fence line of factory farms, and how it's utterly destroying their quality of life, their health, their property value, their ability to breathe. And so I think there's when things happen over a half century, the way we've seen this progression in environmental justice, I think it's much easier to say racism is going on, that it's more problematic than just a social inequity that could be more broadly characterized. So I think that's important in thinking about how the movement advocates and presents itself and communicates. And then it's important to realize that we have such blunt legal instruments. So we're fighting a losing battle when the toolkit doesn't have sharp instruments. So the Equal Protection Clause, which is supposed to be one of our champions to stamp out race discrimination, utterly failed the environmental justice movement about the turn of the century. And then we saw some promise with Title VI. And that's got limitations. It requires federal funding as a hook, and that's going to exclude a lot of environmental racism and environmental injustices without that federal funding hooked. And then there was a development of procedural protections that happened over the next couple of decades after the brick wall of the Equal Protection Clause not being an ally. And that was promising, but again, to the extent we've got flagrant racism going on, procedural protections is not nearly enough. It's a step forward. There's participation and there's consultation going on, which wasn't before, that in some cases anyway, and that's helpful. But ultimately, the only thing we really have substantively is what's happened in the past couple of years with the Inflation Reduction Act and the idea of funding to advance the ability of these communities to be able to have clean energy transitions that they otherwise wouldn't without that federal funding support. So that's substantive in a way, but still not where we need to be in terms of substantive protections. So I would just frame one question for all of you to be thinking about as you hear the rest of the case studies, is that climate justice is taking off in a way that might benefit environmental justice, more of the traditional environmental justice, in terms of what tools are now being used to advance climate justice, and how might some of those legal instruments and strategies come into play into what we've seen over a half century of the more traditional environmental justice scenarios, because we're still seeing those fence line communities, those sacrifice zones, and we have to continue to be persistent and creative about what legal tools are going to be worthy of advancing and protecting these communities. So we're going to hear now 3 case studies that take us one state at a time into different realities of environmental injustices and environmental racism. So Carlton, you're next.
Thank you very much for that, Randall. And I'll begin by saying that the paper version of this, which is maybe not a version of this, but is related to this, is going to be coming out in the upcoming Symposium journal piece, but it won't include the remarks that I'm going to be giving today, which are more kind of focused around on the ground and in the weeds, and that paper is focused more in the theoretical context. And just to set the stage for that theoretical context, it's more or less saying that if we want to do sustainable work moving forward, we have to center equity. This is not a new idea, because it goes back to Our Common Future, also known as the Brundtland Report, where they explicitly talked about equity as a necessary part of having sustainable development. We can see it in the Sustainable Development Goals that have been adopted through the UNEP, and we can see it in Agenda 2030. But in the United States, somehow sustainability just kind of dropped equity right to the ground, right? So we have LEED certified buildings because they use a certain design process. We don't care about the labor. We don't care about the neighborhood. We don't care about any of those things, which are essential for sustainable development, yet we would call it sustainable. So the paper gets into the essential requirement for us in the United States. We're interested in environmental protection and nonprofit organizations, state government, federal government, corporations, to center equity. And it suggests that to do that, we're going to need to move beyond what we can learn from our current Supreme Court's interpretation of the Equal Protection Clause and what intent requires. And so I recommend that organizations and institutions look to a social psychology theory known as social dominance theory. Now, those of you who have had sociology classes or social psychology classes in the last 2 decades would know what I'm talking about. And the rest of us are like, I don't know what he's talking about. But social dominance theory is a well-established theory now that connects up individual psychology with broader sociological phenomena that take place. And it reveals that across different societies, across time and across geography, irrespective of the political structure, irrespective of the religious orientation, irrespective of the economic system, so monarchies and democracies and republics and socialists and capitalists and all these different kinds of systems, and religious groups, Muslim and Hindu and Christian, right? And all of these systems and organizations have what experience calls group-based hierarchy. And group-based hierarchy is hierarchy where you can look to a particular group identity, and the members of that group have a disproportionate share of what they call the positive social value of that society, right? We might think about our context of social goods that we talk about, right? They have a disproportionate share of education and income and wealth and employment and quality housing and quality food. And you also would look and find that the other side of the hierarchy represents people who have a disproportionate share of what we might call negative social value. So incarceration, poverty, lack of access to quality housing, lack of access to quality food, lack of access to health care, lack of access to education. And so you could see this positive social value, negative social value in the way that some people have an overabundance and some people lack it almost altogether. And so when you see what you want to think about what that looks like when it plays out, you might want to think about, not today, but historically under the caste system in India, right? There was the legitimate distribution of positive social value to the top of the hierarchy and denial of positive social value or disbursement of negative social value to people. You might think of it in the context of being in Rwanda, even in the 80s and 90s between the Hutus and the Tutsis, right? Or you might think about the time of troubles in Northern Ireland and think about Catholic and Protestant. Or you might want to think about being in Europe historically and even today and the difference between being French or German or being Roma, right? And so these group identities result in different kinds of spaces where people land on the social hierarchy. And my argument is that we should look to this theory to help us understand how, in the environmental context, what it's going to take for us to achieve environmental justice. Because really what I argue environmental justice is a reflection of social dominance in the American society based on race and based on socioeconomic status. And so your group identity based on your racial identity and or your socioeconomic status in this country decide your access to positive social value. And I bring that conversation into the environmental space to talk about access to positive environmental social value and negative, right? So the benefits are clean air, clean water, access to green spaces, lack of truck traffic, lack of fence-lined communities, and the noise associated with it and the nuisance impacts. And then the negative social value is an overabundance of polluting facilities and polluted air and polluted water and lead in your pipes and lead in your paint, right? And lead in your soils and water pollution and air pollution and truck traffic and noise and landfills and all the nuisances associated with that. And so ultimately the social psychologists tell us, well, how does this work? It works in three ways. There's the ideology of dominance, where we justify and legitimate why some groups have a disproportionate share of the good and other groups have a disproportionate share of the bad. So if we go back to India, we might say, oh, then this is a matter of where you land in the karmic spectrum, right? Your positive karma has resulted in you being at the top of the caste system, and your negative karma has resulted in you being at the bottom. Meritorious karma. Or you might be in the United States in the 1700s and you might be walking along and you have a big plantation and you have a child that asks you, how come those dark people are enslaved? Can that happen to me? And you say, no, that can't happen to you. The only reason they can be enslaved is because they were cursed by Noah. They're the descendants of Ham. And because they're the descendants of Ham, it's okay to enslave them. Because this is at a time when Europe has decided slavery is no longer allowed. White slavery was prevalent in Europe, and then the church says, we can't do that anymore. We're Christian, we don't do that. And then they had to have a justification why it was okay to do that to African people. And first they said they didn't have souls, and then the Pope was like, no, we can't say that. And then it's like, well, they have souls, but there must be some reason they're cursed. So the curse becomes a justification, and you can read this in American history, it's the justification for enslaving people. That's a hierarchy-enhancing ideology. It's the idea, what Ibram X. Kendi might call, right, the racist idea that's at the heart of racism. Those are the hierarchy-enhancing ideas that legitimate saying, well, of course, in the 1800s, we're not going to let a woman go to law school or become a doctor. That's ridiculous. They lack the rationality. They're too emotional. There's no way they could handle it. They don't have the capacity. And so those hierarchy-enhancing ideas then become the way that it's normalized and is made to make sense to us why some people should have these things and other people should not. Well, that's what exists in the environmental context. In addition to the ideas, though, there are also the institutions. And the institutions that produce hierarchy are those that distribute more positive social value to people at the top than they do to people at the bottom. Or they distribute more negative social value to people at the bottom, and they don't bother with the people at the top. So all we have to do is say one word, policing, and then that just all the holes just fill in for us, right? We just know exactly what you're talking about, whether it's police brutality, whether it's arrest, whether it's incarceration, whether it's indictments, whether it's sentencing, whether it's patrolling, we just know that it has a very racial nexus that's associated with who gets all of the good stuff. And so in that context, there are also environmental organizations. And environmental organizations may be distributing more positive social value to people who already enjoy it and allowing for or sending directly more negative social value to people who are already overburdened, right? And so what I say in the article is that environmental organizations have to look at their record to figure out what they're really doing around environmental justice. Is my advocacy, are my litigation decisions to benefit everybody? A rising tide lifts all boats. Am I just concerned about everybody's clean air? Am I just concerned about everybody's access to clean water in the river? Because if you are, you're probably just promoting the status quo. And the status quo says people who don't have a boat drown when the river goes up. Right? Because they're at the bottom. And if they're not surviving with the river where it is, how do you expect them to float up when it goes up? So in the reality, the piece kind of provokes a little bit for environmental organizations, wherever they're state, private, nonprofit groups, to calculate, are you redistributing positive social value in the environmental context to communities that are already overburdened? Or are you kind of seeing that those who already have it just have more of it? And what these cases do is tell us a couple of examples of how we might see that played out in the context of the Army Corps of Engineers. Now, in Brown Grove, Virginia, what took place is a wetlands permit was being requested of the Army Corps of Engineers to build a Wegmans distribution center. And a wetlands permit that was requested was to build it in this community known as Brown Grove, which really was founded by a woman who was enslaved and decided to settle and resettle and started a whole town and whole community. And her descendants, many of them own land there and some still live there. And so the Wegmans wants to locate there. And over time, a number of disamenities have located there, a concrete plant, a landfill, a regional airport. And so Wegmans wants to come in and also locate there. And this kind of is going on, you know, I think they cited it earlier in terms of wanting to use the space, but think about the end of the Trump administration as a time period when these decisions are being made. And so the Corps investigates and does an environmental assessment of Brown Grove. And these are the things that they say they heard. So they say they heard from the community that there were concerns about the proposal. And they said there were concerns about increased traffic and trash and noise and groundwater contamination and flooding. These are the things that they identified. And they ultimately go forward in the environmental assessment and they make a finding of no significant impact. Having reviewed the information provided by the applicants and all interested parties and an assessment of the environmental impacts, I find that this project action will not have a significant impact on the quality of the human environment. Further, considering Executive Order 12898, which is Executive Order on Environmental Justice, they say that they have an obligation to and have considered whether there are any disproportionately high adverse impacts on minority or low-income populations. And they say that the proposed project would not use methods or practices that discriminate on the basis of race, color, and national origin, speaking to Title VI and saying that they're not violating EPA's Title VI regulations. And they say, nor would it have a disproportionate effect on minority or low-income communities. That's their whole exam answer. There is no analysis. There's just a finding. And when you look at this decision by the Corps, you see that the community articulates problems. And one problem stands out for me in particular, which is the problem of flooding. And the Corps says, we observe standing water in the area of the wetland that's going to be removed. We observe standing water in other areas. And then they say, when we get to the discussion specifically about concerns about that were raised about flooding, the Corps says there were comments that were raised that do not require further discussion because they address activities or effects outside the Corps' purview. Concerns include local zoning, past upland development practices, regional flooding, general health problems, traffic regulations. So in the Corps' requirement to make a determination whether an environmental impact statement is necessary, they're supposed to look at the impacts on the human environment. And in looking at the impacts on the human environment, they essentially say, these impacts are outside of our authority to look at. And what really boggles, my mind about this is, what does it take to get the Corps of Engineers to stop being a hierarchy enhancing institution? So I close with a consideration of another case that when I recently was working in Biden's administration, running the Office of Land and Emergency Management. And that's the office that's responsible for toxic waste sites, Superfund, the Resource Conservation Recovery Act, which is hazardous waste, as well as emergency response and some other programs. And when that was happening, we got word that there was a Superfund site in Matagorda Bay, Texas, that the Corps had a permit requesting to dredge it in order to widen it so they could bring in bigger ships so that they could get the fuel necessary to help our allies in Ukraine to be able to have the fuel they need to win the war. And so there were people who were against this because of potential climate impacts. There were people against this because of the potential impacts to the Bay and to the communities that were there. And so we were able to have conversations with the head of the civilian office. We were able to travel down to Matagorda Bay together. We were able to meet with community groups and the Army Corps of Engineers kind of district staff who were making the decision and in charge of the decision. And we were able to have a conversation, and we reviewed the environmental impact statement and said we thought it was inadequate, both in terms of its analysis for environmental justice and then just its basic analysis. So as an agency, EPA had kind of given a hem and haw response previously about it, but we kind of took positions, myself and the head of the regional administrator for Region 6, Earthia Nance, and said, we think there are real problems. We think there are real problems with this EIS. We think you need to do a supplemental environmental impact statement. We don't think this passes muster. And notwithstanding any of the efforts that we made to try to get the Corps to move, ultimately what took place was that if you read it on the Earth Justice website, you can get a really nice report as they explain that they got a victory in their lawsuit against the Corps when in December of 2022, the Corps decided that they were going to do a supplemental environmental impact statement in the Matagorda Bay. And their decision to do the supplemental environmental impact statement was a result of what they said were some miscalculations with the impact. There was literally, when I said there was a Superfund site, the Superfund site was because there was an Alcoa plant that had mercury, and the mercury wasn't just limited to the land, it went into the bay in substantial amounts. And the remedy was to leave it there. That's the remedy, because soil deposition was on top of it and you didn't want to dig down because you would disturb it and you would basically continue to bring more and more and more up. So leaving it there was the remedy. The dredging was literally going to dig everything up. So the Corps ultimately says we had some miscalculations in terms of the volume of mercury that would be dug up, and therefore we're going to do a supplemental environmental impact statement. Now, what's the difference between these two cases? I think the only difference is who was standing with the people in Brown Grove at the time it was before the Corps. There were people who got involved. I think SCLC got involved. NRDC looked at it. There were some of the local attorneys who looked at it. But ultimately, it's Earth Justice's lawsuit, I think, that pushes the Corps to have to defend this to defend this EIS, when EPA was at a time that it was not going to stand up and back them up. I think that's what produces the difference. So ultimately, what's the lesson learned about hierarchy enhancing institutions is that they have to be forced to produce different outcomes, because status quo is like swimming downstream. But if you're going to bring about change and promote environmental justice, it's constantly swimming upstream. And we need all hands on deck to lean in and support these kinds of communities that don't necessarily raise the big climate imprint like Matagorda Bay does, but Brown Grove doesn't. But the people's experience of harm isn't necessarily any less. And unless people who believe in environmental protection are as committed to environmental equality as they are to addressing climate change, I think there's questions about whether people are really committed to justice or if they really are just concerned about the adverse impacts that they will suffer from climate change. That's kind of a lob of a bomb. I know, I kind of threw a bomb out there, right? I kind of threw a bomb out there. But I mean, I do have to wonder, right? Because some people are talking about environmental justice now. It's a very big thing to talk about it now, but it's a lot less to do it and invest resources. And I'm not sure that I've seen all the organizations that are talking about it invest the resources to, as some people would say, to be about it. All right, so with that, I'm going to close. Thank you very much.
Well, I told you we were going to end strong. So, and we're not done yet. So, thank you very much, Carlton, for those very informative and inspiring remarks, both from the theoretical down to the practical examples of this. And I think that it's all of you who are in law school entering your legal careers, you're entering a different landscape, which is, I think, really positive. So when I was considering a career in environmental law, it was about the traditional, more mainstream environmental NGOs that drew my interest, and there wasn't that other path of those that kind of merged environmental protection and social justice in a very meaningful way. And they range from now to the national level to the local level, and they're doing really impactful work. And so your simultaneous passion, if you're anything like I was, to protect the environment and protect communities is now much more accessible in terms of how you chart your careers in this space, which is empowering. There's lots of good work to do out there, and there are more opportunities to do that good work, I think, with trails blazed, but still, as Carlton mentioned, it's an uphill swim, upstream swim. So turning things now to Rebecca Bratsby's, both Carlton and Rebecca have been part of my environmental justice journey for a while. I have great respect for their work, and of course, new allies like Ariel and Brittany also inspire me in many other ways. One thing that comes to mind from Ariel's earlier point about full circle is that earlier in my environmental justice career, Carlton was a keynote speaker when I was teaching at Florida A&M College of Law in Orlando, and now here we are 12 years later or so, I can't believe it, at a symposium on environmental justice again, and so much has changed and so much has stayed the same, kind of that feel to it, and the important work still remains ahead of us. So Rebecca's doing a lot of that important work, and we're going to hear from her on a New York-based case study on environmental justice.
All right, so thank you. Tough act to follow, geez. But so yesterday, Carlton and I realized that we met each other for the first time in Durban in 2006. So, it's great to be back together. And I'm not going to talk about the definition of environmental justice because we just heard that. We heard a wonderful definition. But I do want you to keep in mind as I talk about what I'm going to tell you about New York, that there are two aspects to this, right? There's substantive justice about like who has benefits and burdens, and their procedural justice in terms of whose voice matters, who gets heard, who gets listened to. And so I'm going to focus on New York City, and I'm going to talk about 3 different examples that are stories of environmental justice in action. Each of them is partial, each of them is contingent, but they're victories nonetheless. And I find when we get together to talk about environmental justice, what we really talk about is environmental injustice. And we don't talk about what does it look like to build a different world. So I want to give you 3, they're partial, they're contingent, but it's 3 examples of what does it look like to build something different. So my story starts with structural racism. The story starts centuries earlier with colonization or with the Middle Passage, but I'm going to start in 1938. This is the homeowners loan corporation red line map of New York City. And it's highly racialized. The report accompanying the map explicitly says that too many Black people or too many Jews in a neighborhood is a reason for a hazardous rating. So what was the Homeowners Loan Corporation? During the Great Depression, the United States created this organization to be an economic savior for homeowners who had distressed mortgages. And it did, in fact, save the homes of 1 million homeowners. But that 1 million saved homes was not equally distributed throughout society. It was 1 million white homeowners. So the areas that are labeled green, and there are very few of them in New York City, were had the highest investment potential. Blue meant it was still pretty good. Yellow is an area in decline. You can see a lot of the cities area in decline. And red was hazardous. Consequence of labeling something a neighborhood hazardous was that the federal government wouldn't invest in it, private investors wouldn't invest in it, and that starved Black communities because overwhelmingly the communities that were labeled red, labeled hazardous, were Black communities. Now, this is illegal today, right? The Fair Housing Act of 1968 made this illegal, but I want to show you something about its enduring effect. So this is today's population in New York, right? They don't make the Black areas of the city red anymore. But if you look at the blue is the white part of the city. And if you look at everything that isn't blue, right, that's the places that are majority Black, majority Latinx, majority Asian. And you can see there's a pretty close comparison. Another thing you can see is we have a really freaking segregated city, right? This is a lasting legacy of structural racism as embodied in that 1938 map that directed funding. So if we compare the red line map to various environmental and health issues, we're also going to see a clear correlation. Here's the heat index map, heat vulnerability map. As the climate changes, heat vulnerability is going to increase. It was going to get worse. The most vulnerable are those in substandard housing. You can see there's a really close correlation between where did we starve of investment and where are people heat vulnerable because they live in substandard housing, because they don't have access to air conditioning, because they bear so many cumulative burdens that they have a high level of pre-existing medical conditions that make them more vulnerable. Where are the neighborhoods with few trees and no green spaces? Food insecurity, same story, same map. And then there's childhood asthma, which is a proxy for pollution exposure. The same neighborhoods that were redlined, that are majority Black and Latinx today, have the highest heat vulnerability, the most food insecurity, and they also have the highest childhood asthma rates. And childhood asthma is the biggest predictor of days missed from school, which is in turn the biggest predictor for involvement in the criminal justice system. There is a direct link between environmental injustice, racism, and mass incarceration, particularly because the neighborhoods that are most overburdened with polluting infrastructure are also the neighborhoods that are most targeted for over-policing. That's certainly the case in New York. Which brings me to environmental justice initiative number one I want to talk about, renewable rikers. I have spent almost a decade of my life working on renewable rikers. I think it's really exciting. I hope you'll think it's exciting as well. So what I just showed you, right, is the present that we have built for ourselves and for each other. But it doesn't have to be that way. Pointing out the structural injustice, the structural racism is not the end of the story. That's the start of the story. Now what we talk about is, what do we do about it? And there is a lot we can do about it. We don't have magic wands. We can't fix everything. But boy, can we make changes that matter in the lives of individuals, in the lives of communities, that build justice and build towards justice. So this man, this is Recorder Richard Riker. He is a member of the von Ruyken family. The von Ruyken family were Dutch immigrants. They anglicized their names after the British took over New York. And you can't talk about structural racism in New York without, at least I don't think you can, without mentioning him. I try to mention him in every talk because there is not a bigger villain on the planet, as far as I can tell. So he was New York's recorder, which was a municipal judge in the decade before the Civil War. In that capacity, he was tasked with enforcing the Fugitive Slave Act and returning people who had liberated themselves back into slavery in the South. Okay, that's bad enough. But he did far more than that. Along with two other high-ranking officials, Rikers was part of what came to be known as the Kidnapping Club, a scheme to grab random free Black people off the streets of New York, declare that they were fugitive slaves, deny them the right of habeas corpus to prove that, in fact, they were free, and send them into slavery. And I can't imagine a bigger villainy than that. So the reason I'm telling you that is if you think about Rikers Island, past is prologue. The differing perspectives that white and Black New Yorkers had, which you can see on here, right? To white New York, recorded Riker was a good, kind-hearted judge. They wrote poems about the man. Whereas to Black New York, he was a menace. If you think about the way that white and Black New York view Rikers Island, right, view the jail on Rikers Island, you can see very real parallels. Right, over-policing, mass incarceration, brutality at Rikers Island, Black New York bore the brunt of that, while white New York largely saw nothing amiss and still largely sees nothing amiss. Changing in important ways. By the way, I just want to point this out because I love this. This is David Ruggles, abolitionist, reputedly personally led 600 people to freedom, including Frederick Douglass. This is a cartoon about him showing up with two white allies before Richard Riker to try to get the release of somebody who'd been captured. This is the first American newspaper cartoon to feature an actual Black person as opposed to a generic caricature. So I think that's really cool. I'm into history. That's the book I wrote about it. This is Rikers Island. Oh, it's not showing you. Rats. So if you could see this map correctly, you would see that the actual island, the original island, is like 98 acres. It was built out into the 413 acres it is now after New York acquired it. It remained the private property of the Rikers family, was deeded to them by Governor Stuyvesant as one of the last things he did before the British took over New Amsterdam and turned it into New York. It was Lenape land, right? He had really no business patenting it to the von Ruyken family, but he did, and the British ratified it. It was their private property until 1884, when New York bought it in order to turn it into a prison. And in 1932, Rikers became the main jail of New York City. Most of the current expanse of the island was built using forced prison labor to dump Manhattan's coal ash into the East River to reclaim the shoals and build this island. From the very beginning, it was a disaster. This is literally a penal colony. It is connected to the rest of Queens by one bridge. Otherwise, it is completely isolated. By every conceivable metric that you could measure something, it is toxic. In addition to the brutality that occurred there and continues to occur there, it off-gasses methane because it's made out of coal ash. Also, it's in the flight path of LaGuardia Airport. The noise level is unbelievable. And this is a jail. More than 80% of the people who are sent there are convicted of nothing. They are pretrial detainees who are only there because they don't have enough money to pay bail. And overwhelmingly, they are Black and brown. They come from those same neighborhoods that were originally redlined. And I don't have a map of that because it's really hard to find a map of where do the inmates on Rikers Island come from. But they come from 5 dominantly Black neighborhoods. So this is the jail. This is not supposed to be there. Okay. So under the leadership of Just USA, which is an organization founded and headed by formerly incarcerated individuals, the goal to shut Rikers Island gained power. And it was an audacious campaign. It didn't say, hey, let's make Rikers more humane. Let's make it a better prison. It was like, no, shut it down. So our first speaker started us off today talking about being audacious, right? Thinking big. That's what the Close Rikers movement did. It's a really important lesson. Because if you want transformative change, you need to demand it. You might not get it, but for sure, if you're not asking for transformative change, you are not going to get it. So I just want to emphasize, right, going back to that notion of environmental justice about, right, procedural justice and substantive justice, right? This is a campaign for substantive justice that is led by the people most impacted. The voices at the front of this are the impacted communities. And so in 2017, the then Speaker of New York City Council requested a report, appointed the former chief judge of the state to lead it, a man named Jonathan Littman, came out with a report in 2017 that said, Rikers is a stain on the city. It is irredeemable. It must be closed. And local law 84 was passed. The jail must be shut by 2027. That's where renewable Rikers comes in. Closed Rikers advocates paired with environmental justice advocates in the communities that were most impacted by not only by all of the things I just showed you. And they pressed City Council to enact 3 local laws that are collectively known as renewable Rikers, which is a proposal to dedicate a portion of the island to solar, a portion of the island to wastewater treatment and to battery storage, and to remove those facilities from overburdened communities. So this is a vision of restorative environmental justice, and to ensure that all of those changes occur with the active participation of those who are most impacted. There's an advisory council that must be composed of people who are justice impacted and environmental justice advocates. So this month, just like last week, New York issued its feasibility studies saying that, yes, we can do this on this island. We can build a new modern wastewater treatment plant. We can build significant green energy here, and that both things can happen. Our current mayor is dragging his feet, jeopardizing the 2027 shutdown, but we will get there. This will happen. Partial, contingent, but really a victory. No, this is my old slides. Daylighting Tibbetts Brook, because I don't have much time. Small stream that flows through what's known as Van Cortlandt Park. The Van Cortlandts owned most of the Bronx. They were a family that enslaved a whole lot of people. They made a fortune off of enslaved labor. And they donated their property to the city, and it's known as Van Cortlandt Park, even though a whole lot of other people live there. So, so this is a map of what the stream, Tibbetts Brook, used to look like. It used to be a stream that ran from Yonkers down to the Harlem River. But developers decided that what they really wanted to do was to build here, that this could be a very lucrative area. So they buried the stream and they sort of channeled it into the sewer system. New York has a combined sewer overflow system where when we get more than about a half an inch of rain, we bypass the wastewater treatment plants and dump water directly into the river. So we're not in compliance with the Clean Water Act. And this is what Tibbetts Brook looks like today, right? It is hard infrastructure. And it also causes massive flooding on the Major Deegan Expressway, which is one of the highways that Robert Moses forced through the Bronx, devastating communities. And this highway represents a vision of roads as going through communities rather than being for communities. A very racist vision of what roads are for. It's about moving people from the suburbs into New York, never mind the cost of the city, never mind for the people who live there. But anyway, the flooding part of it got people paying attention to the need to do something. And New York City just decided to engage in daylighting of this stream. They're not going to make the new, right? They're not going to rebuild the old pathway because that's buildings and roads and stuff. But they are going to unbury the stream so that all that clean water is not dumping into our sewer system. And it's going to be a vertical park. So it looks like this right now, but it's going to look like that. So this overburdened community is going to have green space. It's going to have cooling. The water's going to be cleaner, and it's going to be a big amenity. So this last project, and then I'm going to stop. This is the biggest power plant in New York City. It's called Ravenswood. This over here, that's Queensbridge Houses, biggest public housing project in the country, 3,000 apartments. Now, the next slide, I want you just to think about what's right here next to this power plant. Well, it's a playground. So this facility emits 2 million tons of carbon a year. It emits vast quantities of ammonia. It emits mercury. It emits lead. But New York has all of these laws, including a cumulative impacts law that is better than New Jersey's. And this is going to be converted into renewable energy generation and storage. They're going to bring off-wind energy there, and they're going to have battery storage, and they're going to knock down this polluting infrastructure, and the property is going to become a community amenity. And for me, this is the view from my window. So for me, this is not just my scholarship. This is very personal. And just Monday night, I had the opportunity to attend this visioning session at this is at Queensbridge Houses to talk about what's it going to look like. What do we as the community want? And at least they're saying they are going to be guided by the priorities that the community identifies for what this transformation is going to look like. So that's victory. Partial, contingent, but excited. And I don't really have to. So one last thing, and then I promise I'm stopping. This is, I'm sorry, 2 weeks ago, a community garden won a case against a developer about land that was in contest because the community had taken it over in the 1970s when, Ford told New York to drop dead. Nobody's investing anything. The Lower East Side was whatever it was. And this community group got together and they said, we're going to make this into a garden. And they did for 40 years. And then in 2010, when everything's great, developer bought it. It's like, I'm going to build luxury condos. And a young lawyer just out of law school took the case for the community garden and said, I'm bringing an adverse possession. And he told me that they threatened him with sanctions because it was ridiculous to suggest, it was frivolous to suggest that adverse possession applied in New York City and in Lower Manhattan in particular. And guess what? 2 weeks ago, the developer signed over the deed because they were losing the litigation. And the coolest thing from my perspective is that the city council member, in talking about it, said something, I'm not going to read it to you because I talked for way too long, that almost parallels the second to last page of Maya's Lot, my first environmental justice kind of book, about the roots of the community and the metaphor of the roots of a tree and the roots of a community, giving it strength to survive and thrive. And that's what I wish for all of us and all of you.
Thanks so much, Rebecca. That was excellent. We certainly have had 3 in a row, and Brittany has the unenviable task of being the last presenter of the day following those 3 wonderful presentations, but I know she's up to the challenge.
You can.
Thank you. Hi, everyone. My name is Brittany Shar. I'm an associate attorney at the Southern Environmental Law Center. I'm based in Atlanta, Georgia. And I'm really humbled to be sitting up here alongside these thought leaders in the EJ space, especially because not long ago I was sitting in your shoes. So I'm really excited to talk to you all about a case that I worked on about a year ago involving a wood pellet facility in a small town in South Georgia. So the issue with this pellet facility is that operating at its full potential capacity, it would be the largest wood pellet facility in the world. And that was a big deal, not only because this is a small rural community, and that would be a huge deal for any community, but also because just 1 year prior to the permitting of this facility, the Georgia Environmental Protection Division permitted another wood pellet facility in the same community. So now this is the second wood pellet facility in 2 years in this really small community in rural Georgia. So before I get into, talking about this community and talking about our legal claims, I just want to give a quick overview of the wood pellet industry because before I worked on this case, I didn't really know that much about it. So wood pellets are a type of biomass fuel burned for energy. And, this industry really considers itself renewable because theoretically you can regrow trees after you cut them down. But realistically, this industry relies on clear cutting mature forests, especially across the southeastern United States, and using those trees to produce these wood pellets that are burned for fuel. It's a problem for a lot of different reasons. Obviously, our mature forests are carbon sinks. They're really important to mitigate climate change. And they take a long time to regrow. Studies have shown that it can take over 100 years for a forest to regrow and sequester as much carbon as a mature forest. So this is a big deal. And it's also a huge environmental justice issue in the Southeast because, most of the time these facilities are located in low wealth communities of color. So you can see on this graphic that there's at least about a year ago when this was made, there were 28 large wood pellet plants across the Southeast, with many more in the works. And another thing to note is a lot of these pellets are not even being used in the US. They're actually being shipped overseas to Europe and to Asia, where there's pretty high demand for these wood pellets because companies that use them get subsidies for using a renewable energy source. So that's a little bit about the wood pellet industry. And now I'll get into the specific community that we worked with in this case. So like I said, this is a community in rural Georgia. It's about 150 miles south of Macon, just outside of Valdosta, Georgia, if anyone's familiar with this area. It's called Adel in Cook County. So pictured here is Dr. Treva Gear, who is a really great advocate for her community, and she's one of the founders of Concerned Citizens of Cook County, which is the group that we represented in this case. So Adel, Georgia is literally divided by a railroad track, and on the west side of town, it's predominantly a Black and Latinx community, predominantly low-income community, and this side of town is also really highly industrialized. So there's a lot of industrial facilities, and they're in a lot of cases right next to residential areas where people are living. And on the east side of the railroad tracks in East Adel, it's the more affluent side of town. It's wider, higher income, and you don't see that same industrialization. And here's a quote from Dr. Gear that I thought was really powerful. She said, "Residents on the west side of Adel have lived alongside industries polluting our air and water for decades, and this has to stop. We simply need to breathe." So I think, this really shows clean air and clean water should be basic rights for everyone, and they're things that a lot of us take for granted every day. But in reality, not all communities are even able to have clean air, clean water, these things that are so basic. And that's certainly true in Adel. So I just have a couple of photos showing some of the other industrial facilities in this neighborhood, just to give you an idea of the context we're working in when I say 2 major wood pellet facilities were permitted in this small town. So this is a propane recycling business, and it's located pretty much in a residential community in West Adel. It's surrounded by houses, and as part of their operations to recycle these tanks, they flare off gases from the propane tanks. You can see a flame coming out of them, and it releases a lot of odors into the air, chemicals, and folks have been concerned about the potential health impacts of this. And, a lot of people say they can't use their outdoor spaces in their homes. They keep their windows closed because it smells so bad. This is a photo of a Bitcoin mining operation that recently was located in this town. So, this operates 24/7, and it requires these big industrial fans to keep all of the machinery at a certain temperature. And these fans are very loud. So this facility creates a lot of noise pollution. Again, people living nearby feel like they can't open their windows. People have literally soundproofed their houses in some cases because the noise is so loud. And what's crazy about this facility is that it uses something like 10 times the amount of energy that the rest of the town of Adel uses. So this is sort of the environment we're operating in. And now I'll get into our case against Spectrum Energy, which is the wood. Oh, well, before I get into that, I don't have a lot of time to go into detail about this community, but if you're interested in learning more, I highly recommend watching a great documentary that Georgia Conservation Voters put out. It's on YouTube for free. It's about 30 minutes long. It's called Abandoned, and I think it's just it's really well done. So highly recommend you check that out if you're interested. So getting into the nuts and bolts of our case, there was a lot going on in this case, and we had sort of two buckets of legal claims. We were challenging the permit that was issued by the Georgia Environmental Protection Division, the state environmental agency. And so we had two sets of claims. We had claims based on the air quality provisions of this permit, and we had claims based on environmental justice issues. So for the purposes of this presentation, I'm just going to focus on our EJ claims. And our claims really stem from Title VI of the Civil Rights Act of 1964. And what's interesting about our case is Title VI does not provide a private right of action. That's what courts have said. So what's pictured here is EPA's implementing regulation for Title VI, which prohibits disparate impact of agency decisions. So not just intentional discrimination, but also indirect discrimination or disparate impact of agency decisions. So again, there's no private right of action under this regulation, but we were in administrative court in Georgia. We were challenging the permit under Georgia laws and regulations. And those Georgia laws and regulations said that in issuing an air quality permit, the state agency has to comply with the Clean Air Act, and they have to comply with EPA's regulations. So that's, technically how we were able to bring this case. And we had, just to simplify our claims, we had a procedural claim and a substantive claim. So our procedural claim was that the state agency violated its obligation to ensure that its permitting decision was not creating a disproportionate impact. It was not discriminatory against this community. Because throughout this case, the state agency maintained that they have no obligation to do any sort of environmental justice analysis, any sort of community impact analysis. They said that their only obligation was to ensure that this permit wouldn't violate the National Ambient Air Quality Standards or the NAAQS, and that would be protective of public health. But there's a lot of literature, a lot of studies showing that complying with those air quality standards are not necessarily protective of public health because they don't take into consideration things like cumulative impacts, things like localized impacts on the communities that are living right next to these facilities. So that was our procedural claim, that the agency didn't do any sort of analysis and they were required to under this EPA regulation. And our substantive claim was that had the agency done any sort of analysis, they wouldn't have been able to issue this permit because this community was already so overburdened by environmental stressors. Others have mentioned EJ Screen, which is EPA's environmental justice mapping tool. We used EJ Screen a lot in this case. And if you look at this community on EJ Screen, any way you slice it, whether you look at the census block that encompasses this facility or a 1 mile radius around the facility, you'll see that it's about 90% people of color. It's majority low income community, and they're in like the 90th percentile for a whole host of environmental justice indicators like hazardous air pollution, proximity to Superfund sites, hazardous waste, all sorts of things. So those were our claims, and we were all set to go to a hearing in administrative court on these claims when we were approached by the wood pellet facility, Spectrum, to begin settlement discussions. So, ideally, the best outcome for the community would be that this facility is not sited in their backyard, right? But unfortunately, the state agency permitted it, and of course, litigation is always uncertain. So when the company came to the table and wanted to sit down face to face with this community and reach some sort of resolution that the community would feel comfortable with if the facility was going to be in their backyard, that was a pretty big moment for this community who for years has felt like their voice hasn't been heard. They've been complaining to the state agency, they've been complaining to their local elected officials, but no one's listening. So the CEO of Spectrum, who's Canadian, flew from Canada to South Georgia and, excuse me, spent a few days sitting at the same table as these community members and really, really listening to their concerns. So this was really more than just a box checking exercise. It was an opportunity for this community to have their voice heard and to have their input meaningfully incorporated into the outcome in this case. So we did end up reaching a settlement agreement that did a bunch of things that are pretty good and went far above and beyond what a permit would have given this community. So just to give a few examples, there's more public health protections in this agreement than would have been required with the permit alone. There's stronger enforceability provisions. So this settlement agreement actually lists the community group, Concerned Citizens of Cook County, as an enforcer of the agreement. And so if Spectrum violates any term in the agreement, they will need to pay $25,000 into a community health fund that goes right back into the community. It also provides for greater transparency between the community and the facility. So instead of monitoring their emissions annually, this agreement requires them to monitor every month. And at the same time that they report those results to the state agency, they also have to report the results directly to the community so that, they know what's going into their air. They can, have folks review for them, review it themselves and see if there's anything concerning going on. This agreement also provides for meaningful community participation and engagement in a couple different ways. One, it requires the facility to host periodic community meetings where their leadership goes and has to listen to concerns of the community and is required to meaningfully respond to any concerns. It also requires them to establish a hotline that folks can call into with any real-time concerns, and it has, provisions for them to respond within a reasonable amount of time to these concerns. And then the last thing I'll highlight here is this agreement requires the facility to purchase and install tens of thousands of dollars worth of air monitors throughout the community and air filters in vulnerable locations like daycares and churches and senior centers. So, this was a good outcome for this community, short of this facility not being cited there, just because, we're dealing with a state agency that says they don't need to do any sort of analysis on the cumulative impacts on this community, which, of course, we think the agency needs to step up and do more. But this was a really positive result. And I spoke with Dr. Gear, who was one of our plaintiffs a couple weeks ago, and she said, she's getting calls from other communities that are going through similar things, and they want to learn more about this agreement and how they got there and use it as a model for their community. So that's really cool and energizing to see, the result of this case isn't just helping this community. It could potentially help communities across the Southeast and across the country. So that brings us to today. We reached the settlement agreement about a year ago. And to my knowledge, this facility has not begun construction. If and when they do, we will be involved in enforcing the terms of the settlement agreement and just continuing to work with the community to have that advisory relationship and address any issues that come up. We also filed a Title VI complaint with EPA's External Office of Civil Rights. So that complaint is not related to this facility specifically, but related to the Georgia Environmental Protection Division's permitting processes generally. like I said, they say they don't need to do any sort of EJ analysis. They say, compliance with the National Ambient Air Quality Standards is all that's required of them. And we are challenging that with EPA, and that complaint is pending. And finally, we will continue our advocacy against the wood pellet industry, and raise awareness about the EJ issue that it creates throughout the Southeast. Thank you so much.
Thanks so much, Brittany. That was a great way to close things out with a lot of practical examples of some of these EJ principles and strategies and tools, and a happy ending, which is always important in this space. So I know you have questions, and happy to entertain a few, and then encourage you to continue the dialogue with these great panelists before they're no longer in the building. Should be a shame. Yes.
Hey everyone, it's been a wonderful day. Thank you so much for your work. I'm Sandy Alexandra Durst on LinkedIn. I'm part of a very small, just starting organization, Go Go Garden. And I wanted to know from your point of view, how edible plants and public fruit trees outside of community gardens, such as in parks, on the street, like in Valencia, Spain, how that can help environmental justice initiatives on sites like not near surplus sites, not in contaminated sites, of course. How fruit trees and public food can be provided for communities. There's also flyers outside if you want to sign a petition.
I have a couple of friends who are chefs, and in New York City, we're always talking about that. And there are a couple of restaurants, both in New York City and in Philadelphia, that have gardens right outside on the sidewalk. And you can just, as you're walking by, like pick some thyme and basil and whatever you need. And it's a really cool idea. It requires infrastructure, but it could, there's no real reason that we can't have, as part of the green space that we're trying to add to so many communities, to have it be, edible. I mean, what I would say is what would matter is that it be indigenous, rather than species that we're bringing into a community, because otherwise we're going to lose the ecological benefit. But I think it's a cool idea.
Very powerful presentations. Something I want to comment on is a thread that I think common thread noticed in all the presentations today, which was challenges in the empowerment of impacted communities. We heard that from the youth activists, the indigenous lawyer about, and the issues with respect to racism. And this is a topic I'm very passionate about in my own work as a human rights lawyer. It's extremely important to me that that's happening in the strategic litigation that I do. But when we hear, like, for example, Dr. Waterhouse talking about the pervasive, systemic, value-based issues that perpetuate these problems, it can be really, hard to keep hope alive that we can truly empower impacted communities to not only have a voice, but to inform policy and advocacy efforts, because I think that they know the problems, they know the actors, they know the solutions. We just need to listen to them. So my question for you is, for legal practitioners, what practical advice do you have that what can we do in a more present moment to empower these voices, to make them more a part of the process?
So I do think the bipartisan infrastructure law, and even more so the Inflation Reduction Act, provide pretty substantial levels of resources that are targeted towards communities to both address environmental justice, but also to address just transition. And I think the way many of those grants have been designed is that they're supposed to be collaborative. So communities need good partners to help them build capacity in order to take advantage of literally billions of dollars of grant money to help them address some of these issues. And so people and organizations who are interested in these issues, the design was intended to build the kind of relationships that I'm suggesting need to be in place with our institutions that are environmental advancing institutions, to make sure that they're doing that kind of environmental advancement work in collaboration with members of overburdened communities. And it provides a financial kind of incentive for both entities to work together. And this helps to build up the capacity of those communities to support themselves as time goes on, to be more powerful partners. So I think that's one space where that can happen and would be meaningful.
And I'll just
Oh,
build
go
off
ahead,
of
go
that
ahead.
really quickly. Yeah, you're right. There's a ton of funding that's coming out, and that's very exciting. And I think what's also exciting is that there are mechanisms to ensure that communities can actually access this funding, because that's really tough a lot of the times. You know, people, obviously everyone's busy, you know, there's other things going on. People don't know how to navigate the grant system. But there's things like the TIC-Tacs or Thriving Community. I don't know what it stands for, but it's there's all these acronyms. But you know, groups that are dedicated to working with community groups and helping them navigate the grant making process, navigate funding applications. So I think that's a really important and exciting development as well.
Yeah, and I think just to add to that, just sharing other success stories. I think the example, Brittany, that you provided of just the way that these community agreements are now almost multiplying in other places because people are aware that this is an option. I think the more that we're able to showcase solutions and show that, you know, action does work, it incentivizes and invigorates communities to hopefully get more involved.
Can I add
Yeah.
one more thing? It may not be as sexy for clinics, but community groups need kind of basic capability support, like the 501c3 stuff. I mean, like, we can have students to help them fill out the 501c3 so they can be eligible to get the federal grant money. It's not the big environmental kind of casework, but it's essential for them to be able to get the support to be able to do the environmental kind of work. We need partners and attorneys who are willing to do that and provide that kind of assistance.
I also think we need lawyers to recognize that, like, we are allies, not principals.
Mhm.
And that, you know, our job is not to save anybody. Our job is to support people as they save themselves and, quite frankly, the rest of us. And, you know, that's like a professional hubris of this idea of, you know, I can fix your problem. And we can't even fix our own problems as lawyers. We're not fixing anybody else's problems. But we do have really useful skills that we can put at the service of communities at their request. So it's, what do they say? Like, lawyers on tap, not in
On top.
On top, yeah. I couldn't remember what the other part was.
This was just a fabulous panel. I have and Ariel, you started out with the theme that everyone else has addressed too, which is this idea that we have to be concerned about environmental benefits in communities as opposed to just stopping environmental harm. But so what I notice in Louisiana a lot is whenever there are benefits that start developing in the community, whether it's opening up a waterway, access to water, making things nicer, sometimes there's even pushback within the community because they are afraid of rising prices and gentrification. So that's the sort of shadow side of a lot of that. So how are they dealing with that in the creek that you're talking about, or any of the other examples?
So that is, you know, one thing I didn't point out, because I knew I was talking way too long, is that if you look at the rendering, all of the people they show in it are white. Even though this is in a part of the Bronx that is like 90% plus Black and Latinx. What I would say is, like, this project is being very much community driven. The Parks Department is in charge of it. So that's good, because it's the Parks Department, not DEP, not the environmental people. which, it's a shame that you say that, but it is true. Like the Parks Department is in every neighborhood in a way that DEP isn't. And they have been very intentional about community consultation and from years. We're years into it now. There have been multiple sessions of community involvement. And quite frankly, this is alongside the Major Deegan. It is going to be a buffer between the Major Deegan and the communities, but it's not in the community. So it's not having the same kind of impact like the High Line did, which completely gentrified an entire portion of the city.
Let me also add that you're going to tell me if I'm pronouncing her name right, but Elizabeth Yampier?
Yampier.
Yampier. So she has led activists in New York, particularly around issues of gentrification and how to address them. And what she argues is that you have to keep the working class base in the community. And so rather than just eliminating all of the industrial kind of sources of pollution, we should focus on greening them. Because once greening them, right? So not bringing them, greening them. Right. So rather than just elimination, she makes the argument that the only way to prevent Starbucks from kind of coming in and becoming the replacement for the mom and pop shop that's there is to make sure that that industrial facility that is where folks may be working in the community remains in that community, but you mitigate down the adverse impacts on the community so the community holds on to its identity and kind of pushes back on what gentrification might otherwise produce.
And that's
And
like the just transition at work. right?
Yeah.
Like that's the whole point, is making sure that there are reasonable alternatives to ensure that everyone is included in that transition. Yeah, totally.
And the organization that she leads is called Uprose. It's an acronym for something, I have no idea what, but they do incredible work across New York City, and they're worth checking out.
Thank you so much for the enthusiastic presentation. It's a good question, but it's if anyone really wants to answer. Professor Bratsky's brought up like how you guys have the combined sewage overflow system in New York, and I'm from Buffalo, New York, and we have that same system as well, and how it's not really important to water act, but overhauling it requires a lot of infrastructure. So I'm just wondering if any of your guys' communities or anyone you know of has been doing any work to add like green infrastructure or change the infrastructure of your systems.
Yeah. So Renewable Rikers, the new modern wastewater treatment plant we're going to build on Rikers Island, is going to move New York because it's going to have so much more capacity than the 100-year-old plus crappy facilities that are stinky that are in all of these environmental justice neighborhoods. They're horrible. They're going to replace, pun intended, maybe. But so that's one thing. I mean, the daylighting of streams is another really important tactic. Yonkers did it. As I said, Tibbetts Brook is happening. Building bioswales, building rain catchments. It's happening all over New York City. It's probably starting to happen in Buffalo. I know there's some people there who are working really hard on this. It's not going to fix our problem, but it's going to get us a long way towards it. The fact is, we just need a freaking lot of money. And, we got a bunch of it, right, from the bill and the IRA. So hopefully some of this will start to change.
Thank you all for all of these presentations. What are some, I can offer the context, these examples behind this question upon request, but I won't take up too much time. What are some ways that you've seen in many of the cases that you've argued for reducing, preventing, or mitigating the effects of activist burnout, other than putting the onus on the activists and community members themselves and individuals for the toxically positive do self-care, right? Like I said, I can explain the example that.
I don't have an answer, but I know one of the pieces of it is the recognition that we shouldn't expect that community members are going to do all of this work for free. The fact that we provide funding for community members to attend meetings, to come to conferences, to be in events, to provide them with stipends and housing and lodging, which was not the norm when I was coming up in the 90s and the 2000s, and is becoming much more an expected norm today. And then the expectation that when you are a researcher doing work with communities, you're going to provide them with financial support for participating in your activities and not just be there to fund your dissertation or your book, and without the idea that they are somehow getting something along with it. So it doesn't necessarily prevent burnout, but it provides some financial support so that perhaps as much time doesn't have to be spent in the kind of paid workspace, and you're also doing double duty in an unpaid workspace at the same time, right? So it kind of provides some support around that.
And they get the data, right? The community gets access to the
Oh, yeah.
data from the research, which is
Not the norm, but.
Yeah, I was actually going to bring up the funding as well, but I mean, it's a really complicated issue. It's tough because, you know, there's always great advocates in every community, and they really are the best ones to tell their story because they're on the ground and they know what's going on. But, you know, the burnout's a complicated issue, and I think funding's one way to address it. You know, working with communities to uplift their stories whenever you can and provide spaces and platforms, you know, where other folks are sharing, you know, the stories as well. So just echo what you said.
Oh, can I say one more thing? So there's research that's been done recently to show that in terms of the big foundations and where grant money goes for environmental work, small on-the-ground organizations don't get it. So more money goes to a little bit of the social dominance analysis. So the kind of money goes to the big greens that tend to be disproportionately made up of folks who are white and disproportionately not focused on dealing with the problems of the most vulnerable communities, though they're dealing with problems, that they're not focused on those problems. Reversing that formula so that folks who are full-time activists but working full-time jobs can have the kind of money and infrastructure that allows them to get paid to do that kind of work so that they don't have to spend all of that. So it's a little different than providing supplemental funding for conferences and money to attend meetings. Let's give them real grant money, right? If we are concerned as a foundation about addressing environmental justice, let's not give billions of dollars to name the big green and then $100,000 to the small folks who are doing all the work on the ground that doesn't last even for, you know, a year. And let's give some real support to these organizations run especially by women of color and see them as being competent to be able to manage that money. And I think there's an underlying question about why that competence is so questioned on a regular basis.
It might have been the same study that says like 2% of philanthropic dollars, like climate philanthropic dollars are going toward people-led environmental. Same thing.
The last two questions, Sean and then Catherine.
Thank you. So thank you all. Thank you all for sharing your thoughts and expertise. It's been a really great panel, and I definitely appreciate you all taking the time to speak with us. My question has kind of been answered by the latter comments, but a panelist earlier said that litigation really isn't the solution to these environmental justice problems, right? And with you all, from Ms. King to Ms. Shar, right, everything shared has been either the battle or the solution. And so my question is, how could we as advocates, how could we as lawyers, future lawyers, community activists, how can we begin to kind of use these solutions and use our tools to shift the conversation and to shift the resources into those other places that should be the answer?
I believe that there is a way to infuse justice into every programmatic function, right? And so I think that no matter what job you go into after law school, there is an opportunity to make sure that you are ensuring that there is a acknowledgement, ensuring that the voices that aren't in the room are brought because you brought them there. And I think that that might be one way to think through some of the challenges. Yeah, I'm curious what other panelists' thoughts and ideas are on.
Yeah, I think you're totally right. Like litigation is sort of addressing the symptom of a wider problem, right? So it's not the solution necessarily. And I think one solution, Ariel talked about the New Jersey cumulative impacts and EJ law. I think, what I'm seeing is a lot more local governments that are interested in these types of things. In Georgia, we don't have a state EJ law. But we do have counties and cities that are interested in passing some sort of local ordinance or creating a local policy that ensures that their communities are protected. And I think, I'm really excited about the movement we're seeing there. And I think that's a really great place to channel advocacy as well, because a lot of difference can be made at the local level.
Well, thank you all. I just had a question on the Justice 40 initiative. And my question is, have any of these communities, like Georgia or these proposed projects, are they going to receive any of that funding? And if not, why not?
So none of the projects that I was talking about are going to be Justice 40 projects because they're already funded and they're already underway. So Justice 40 actually is modeled on the Climate Leadership and Community Protection Act, which is a New York law that was passed in 2019 that required that 35% of the benefits, whatever that means, of the investment in clean technology was going to flow to disadvantaged communities, right? And that's where the Biden 40, Justice 40 came from. There's a lot of questions about like, what does it mean to say it's a benefit? What does it mean to say it flows to a community? Like there's a lot of questions there, but there's also, I think, has been a real commitment on the part of EPA, on the part of the Department of Energy to push money out into communities that are disadvantaged communities, that are overburdened communities. And and one of the really important things in that has been the TIC tax, has been the capacity building of local community groups to navigate these federal bureaucracies to make sure that they are players in getting that money. And I think that's going to be game changing because what these support centers are doing is creating, and this answers somebody else's question too, right? They are creating an entire generation of people who are savvy about the process, who know how to navigate it, who understand what the funding is, and that they are entitled to it. And I think that's going to change who gets it. I mean, at least I hope it does.
The only thing I would add is I know that the EPA Regional Administrator, Adam Ortiz, out of EPA Region 3, has been in Ground Grove, just recently touring Ground Grove on earlier this year in January, and they're working along with us at the Howard Environmental and Climate Justice Center to provide support for that community. And they've been providing them with a lot of guidance and recommendations about funding opportunities. And so hopefully we'll see, even though they didn't have a win with the Wegmans, that there's additional ways to address some of their needs as a community. So the funds are available, and we need more people to do capacity building to help communities to be able to take advantage of them.
And in Georgia specifically, I think the EJ space really requires a lot of thinking outside the box in terms of, SELC traditionally does a lot of litigation, but we are moving towards doing things like informing communities about grants that are available and doing that important work as well. So not all of the funds have been distributed yet from Justice 40, but that definitely is something that we're getting more involved in, is connecting communities and, just informing folks about the opportunities that are out there to ensure that the people that need the funds can get it.
It's a great note to end on, positive and very thorough. Join me in thanking our fantastic panel, please.